Good afternoon. Good afternoon, and welcome to our 10th annual Martin Luther King Jr. Convocation. I am William McGivern. I'm the Dean of the University of Minnesota Law School, and I want to thank each and every one of you for being here and also for those watching on recording. As I say, we have been convening to honor MLK in this way for 10 years to reflect on Dr. King's legacy. But I think we'd all agree that today, this conversation, this opportunity to renew our familiarity with his mission and our commitment to it, feels more urgent than it has ever before in those 10 years. Because today, Dr. King's legacy is being intentionally distorted by some whose goal is to set back progress toward racial justice and to dismantle the structures that we have built to support it. The internet is filled with punditry that misleadingly claims Dr. King's dream was a colorblind equality rather than an inclusive equity. And if you read the newspaper, which I recommend you do only when you are prepared to be very angry these days, sort of a joke, but sort of not, right? You will find lawyers who have turned the radical anti-slavery 14th Amendment into a tool for reinforcing the status quo. You will find corporations and other major institutions retreating on their commitments to equality. And you will find federal agencies banning observances like this one devoted to Dr. King, not to mention Black History Month, Juneteenth, LGBTQ Pride Month, even Holocaust Remembrance Day. All of this distortion underscores the importance of returning again and again to Dr. King's first principles of racial justice and beloved community. To be sure, we understand them deeply, we oppose their distortion, and we think carefully about what they mean to us today as we confront the challenges we face now. But today I'm glad to welcome Chief Justice Natalie Hudson of the Minnesota Supreme Court and all of you to do just that. And I'm now going to hand this over to our moderator today, our own Professor Chris Roberts, who will introduce our distinguished guest and begin our proceedings. Professor Roberts joined the law school faculty in 2011, and he's an associate professor of law and an affiliated faculty member in our Department of Sociology. He brings an interdisciplinary lens of law, sociology, and public policy perspectives to human rights, international law, and legal history. So please join me now in welcoming Professor Roberts.
Put this keyboard. Thank you and welcome. And I am extraordinarily happy and honored to be here. I'm honored to welcome our esteemed guest, the Honorable Natalie Hudson, Chief Justice of the Minnesota Supreme Court and alum of this great law school. Welcome, Chief Justice Hudson. Justice Hudson graduated from the law school in 1982, where she served on the law review staff and was editor-in-chief of Quarry, the law school newspaper. She was a staff attorney with the Southern Minnesota Regional Legal Services, where she practiced housing law, an associate attorney in employment law and general civil litigation at the law firm of Robbins, Kaplan, Miller, and Cerisi, an assistant dean of student affairs at Hamline University Law School, and St. Paul City Attorney. From 1994 until her appointment on the Court of Appeals, she worked for the Office of Minnesota Attorney General, primarily in the Criminal Appellate Division. Justice Hudson joined the Minnesota Court of Appeals in 2002 by appointment of Governor Jesse Ventura. She was elected to the post in 2004 and re-elected in 2010. She first joined the Minnesota Supreme Court in August 2015 by appointment of Governor Mark Dayton. She was elected Associate Justice in 2016 and 2022. She was appointed Chief Justice of the Court in October 2023 by Governor Tim Walz and was re-elected in 2024. In addition to her service on the bench, Justice Hudson has significant community and professional involvement. She is a member of several associations, including the advisory board of the Minnesota Women Lawyers, the Minnesota Association of Black Lawyers, and the Minnesota Association of Black Women Lawyers, among others. She was selected to serve on the Warren E. Burger Anne of Court as a group leader. Justice Hudson served on the law school's Board of Advisors from 2004 to 2010. She also volunteered at Benjamin E. Mays Elementary School and participates annually in the Minnesota Court of Appeals Dorothy Day Center Cookout. Today, our esteemed speaker will address the topic, Realizing Dr. King's Dream, the role of justice and public service in advancing equality and access. Justice Hudson plans some brief remarks and will then address questions from me, including questions submitted by our students. Before we begin, on one note, first, today's event is being recorded, and the link to the recording will be shared via email to all registrants following the event. So now, without further ado, please join me in welcoming Honorable Natalie E. Hudson.
Good afternoon to everyone, and thank you, Dean, and thank you, Professor Roberts, for that warm introduction. Let me begin simply by expressing my gratitude to the University of Minnesota Law School for hosting this incredible event and for its steadfast commitment to advancing the values of justice and equality that Dr. King so powerfully championed. Of course, this campus and this law school holds special significance for me. I was a student here. I walked these same halls that you're walking as a law student. I was chatting with Professor Roberts earlier, and he was asking me, when did we move into this building? And my class, the class of 1979, was the first class to be held in this building. So this university and this law school in particular helped shape the lawyer and the person that I have become. And thus it is always an honor to turn to this community. I'd also, again, like to thank Professor Roberts for guiding the conversation that we're going to have later today. And of course, I want to thank all of you in attendance, whether you're here in person or whether you're joining us virtually. Your presence today is a testament to how deeply Dr. King's legacy continues to inspire each of us. It is truly a privilege to be a part of this convocation. As we gather to reflect on Dr. King's dream and its ongoing relevance to justice and public service, I find myself both humbled and inspired. His work and his words have long been a source of deep motivation, both personally and professionally for me. His belief in the moral obligation to stand against justice resonates deeply with the work we do every day in the judiciary as well, as we too strive to uphold fairness, equity, and equal justice under the law. You know, I often think about the courage and the conviction it took for Dr. King, who, as you know, was a very young man at the time he took the helm of the civil rights movement. The immense courage and conviction it took for him to stand in the face of tremendous opposition and danger in the heart of the Jim Crow South of the 50s and 60s, to call a people and a nation to stand for righteousness. It is a stark reminder to us today that justice is not simply a lofty ideal. It has to be a lived reality that we create together. And that together part is important because Dr. King believed strongly in what he called direct action advocacy, by which he meant direct involvement by the Black community as well as its allies in boots on the ground kind of activities, the marches, the demonstrations, the sit-ins. He didn't eschew legal action through the courts. He supported the major impact litigation that the NAACP Legal Defense Fund, which at the time was headed by its founder, Thurgood Marshall, He supported that major impact litigation that Marshall was involved in, notably the constitutional challenges to segregation, of which Brown versus Board of Education is probably the most notable. But he saw those legal challenges, that impact litigation, really as complements to his main focus, which for him was the personal, direct engagement by the Black community. He knew that litigation was costly and lengthy, and he wanted the Black community to know that they could make direct and more immediate change by their own personal actions. And so when Rosa Parks refused to give up her seat on an Alabama bus, what ensued was the creation of the Montgomery Improvement Association, which King led. And most importantly, the 1955 Montgomery bus boycott, where Blacks of all stations, doctors, lawyers, teachers, maids, plumbers, boycotted the bus system in Alabama, in Montgomery, for over a year, effectively leading to the end of segregation of that bus system. That was the kind of direct, personal, engaged action that King most strongly promoted. And what he was also trying to accomplish was getting the attention of the nation, the broader nation, particularly whites in the North. He wanted them, and he wanted the full nation to see the marches. He wanted them to see the sit-ins. He wanted them, although he, I'm sure, never wanted anyone to be hurt or injured, but he knew that there would sometimes be violence at those marches, often at the hands of law enforcement. He wanted the nation to see the fire hoses and the billy clubs because he hoped that would change hearts and minds. Often did. The 1965 march from Selma, Alabama, to Montgomery to protest the exclusion of Blacks from voting ended, as we all know, sadly, in Bloody Sunday, which we actually will be, commemoration of that comes up in March, because it was in March of 1965 that occurred. But Bloody Sunday, as awful as it was, effect on the nation. The nation watched and was horrified. And 6 months later, Congress passed the 1965 Voting Rights Act. And so as we begin this discussion today, I want to thank you for the opportunity to share in this moment of reflection, dialogue, and I hope inspiration. Together, let us honor Dr. King's legacy, not just with our words, but with our own actions. And by recommitting ourselves to the values of justice, equity, and service that he held so dear. So thank you, and I look forward to our conversation.
Thank you, Chief Justice Hudson. I remember watching a comedian interview President Obama, had first won the presidency. And the comedian jokingly said, "What are you going to do now that racism is over?" And President Obama, being the good lawyer, challenged the premise immediately and said, "Racism is not over." We find ourselves in a struggle right now that is taking place all around the country that echoes the same struggles that we saw Dr. Martin Luther King fighting for. And those struggles take place not just out there, they take place in here. And we all know that we ourselves are part of those who are taking place in the struggle. And I have talked to many, many, many students over the past week who have voiced a great deal of emotion, lucid opinions, and shared with me their experiences after the law school's DEI position was put on indefinite pause. And I want to begin there. I want to begin there because this is something that is top of mind for students and alumni and the people in this room. And it's part of this ongoing struggle. I say to my students, a lot of times when we find ourselves in what seems to be uncharted waters, that we often have to feel our way through as if there were no lights. We have to feel our way through. And so I just want to begin with some of the feelings that I have, that students have shared with me over the past several days. I have felt from my students a great deal of frustration. I've felt from my students anger. I felt fear, not knowing what's going to happen and what's coming next. And I have heard from a student, I'll just tell one brief anecdote, who came from a southern state that had already banned DEI. And she was on the front lines of that battle in her home state. And she decided to come to Minnesota because she knew it would be more inclusive, it would seem more like an ally. And she said she feels like the bottom has fallen out here. So what can we do? What can you say? What advice, what guidance can you offer us in what's a really challenging moment when the course is not clear as to exactly how we should deal with these challenges that confront us?
Well, several things come to mind for me. First and foremost, let me just say that I understand that, and the anger, I understand what I suspect, and Professor Roberts alluded, is that feeling of abandonment from those you deemed to be allies. And I think I would put the university as a whole and likely the law school in that. Well, and those feelings are real. I don't think you should try to push those down and suppress them. You need to acknowledge them. But what I would say to you is how you process them in your head, and more importantly, or equally important, how you process them in your soul is important. And so what you do next is critical. And to that end, what I would encourage you to do, step back and try to get some broader perspective, because there are many parallels here. This kind of division in our country is not new. Maybe it's deeper division and exacerbated by a number of factors. It is certainly no more divided than this country was back at the time that Martin Luther King. And a part of that perspective, though, is I think, two or three things. One, I think you have to recognize that the university, law school is a part, like many institutions in our country right now, receives federal money to stay afloat for its research, for its many different programs. Thus, it is in a precarious and delicate position right now. They've taken a form of, and these are not my words, I read this somewhere, but I think it fits, anticipatory compliance in pausing further DEI hiring. But I don't think that's a totally unreasonable position. You do not want the U or this law school having a target on its back, because more harm can be done by that in the long run because of potentially precipitous actions taken now. I think you have to look at the long game. And so it is not unreasonable for the law school to use caution until the federal landscape is a little bit. I think you saw that in President Cunningham's letter. It's what I call on the court and what judges sometimes call an on balance approach. You're looking at the entire landscape and looking at the entire picture, trying to determine what, on balance, is the best and most appropriate action. That said, I also believe that this law school, under this dean and this administration, do have a commitment to DEI, and that will continue. You do not have to have a formal position and a DEI sign over somebody's door here in this law school for the principles of equity and inclusion to be practiced and honored in this law school. And you are not powerless. You are not powerless to make sure that that is the case. You still have a voice individually and collectively. You can still engage in the kind of direct action we were just talking about, Dr. King epitomized. You can continue to make your voices heard in your classrooms, to the dean, to administrators. And I think you will find that the dean and the administration are receptive. At least give them the benefit of the doubt until they've given you reason to believe otherwise. And continue that dialogue with others, not just here. This is a bubble of sorts, but in the other spaces that you occupy, in your book clubs, in your other community activities, and with people you don't necessarily agree with. That has to be a part of the discussion as well. And of course, like, as always, it's important what you say, but it's important also how you say it. It isn't constructive in this day and time to, when someone says something to you you disagree with, for you to say, well, that's the stupidest thing I ever heard. That does not foster discussion. Maybe it's, why do you say that? You don't seem to have taken into account A, B, C, and D. What makes you say that? Because maybe their background is different than yours. And so you can foster that, the kind of discussions that we need to have about these issues if you can engage in civil discourse. The other thing I would say to you is that the best evidence of a person's and an institution's future behavior is what they've done in the past. And let me give you some added perspective. Graduated from this law school in 1982. And as I said before, so I was a 1L in 1979, the first class in the building. And there were 250 students in my class. Of that 250, there were 6 people of color. 6. 5 blacks, 2 women, me and my good friend Sandra Miles. 3 men, Al Purum, Demetrius Clemens, and Rodney Johari. And 1 Hispanic woman, Kathleen Olivares, who was from Texas. That was it. I'm sure there were LGBTQ plus students here in the law school at that time, but no one even acknowledged their existence in 1979. It was lonely, and I often felt like the other. Part of the shaping that I mentioned to you in my opening comments, most of that shaping was positive. Here I sit now as the Chief Justice of the Minnesota Supreme Court and the head of the 3rd branch of government. Skills and the tools that I learned to be able to do that, and through my public service career, I gained here in this law school. But this law school also was very isolating at that time in many, many ways. That's part of my shaping too. I've taken that part of my shaping. It is what has informed me now as Chief Justice. Make sure that our court system is as accessible as possible, to make sure that all of the people that are coming into our courtrooms are not othered to the extent we can do that. As isolating as this experience was at times, there were still allies here, and there still are. maybe more than you know. There are several students, or several attorneys who were in first year class, white students, who I was friends with then and I remain friends with today and have supported me throughout my career. I also remember Professor Donald Marshall, who none of you know, and I believe he passed on, Dean, maybe 10 years ago. I'm not sure, something we're in that range. Professor Marshall actually acknowledged our presence. He invited us into his office at times to talk about issues maybe we didn't understand. He acknowledged that our presence here might be a little different than it was for the white students. That was huge, and I've never forgotten that. I regret that I never said that to Professor Marshall, so I say that now to his family. 41 years later, I took a look last night at the entering statistics for the 1L class here at the U. And I wrote it down because I didn't want to get it wrong. 27% BIPOC, 32% LGBTQ+, 55% identifying as BIPOC, LGBTQ+, and or first-gen college grads. 6 of us. These numbers, they do not happen overnight. They do not happen by accident. They happen because deans along those 40 years and administrative staff and admission staff over the course of those 40-some years have made a commitment and taken intentional actions to make it happen. So that's a long-standing commitment of diversity, equity, and inclusion. Is it perfect? No. Will there be shortcomings? Yes. Will there be steps back? Yes. That moral arc that King talked about is long. But it speaks to the high likelihood that this school at this time in history will not abandon its commitment to diversity, equity, inclusion, simply because they've had to pause the hiring of a specific position. Hold them and the university to that. Keep pressing. Keep your voices being heard. Keep it front and center. But put it in that broader perspective. And again, the last thing I would say is I just simply point you to the legacy of the man we're here to honor today. He lived in a time of deep segregation and discrimination, division and anger. Look at the legacy that he left us. A legacy of courage, a legacy of sacrifice, and persistence in the service of those most marginalized in our country. Why should anything less be required of us? One of King's favorite quotes, and I think it's just amazing that a man who was such an orator and known for so many wonderful quotes, and a man of such eloquence, but he had a favorite quote. And I was doing some research on this, and one of his favorite quotes was from the famous educator Horace Mann, who said, "Don't die before you do something for humanity. Don't die before you do something for humanity, before you do something for someone else who cannot pay you." That's the charge, folks. That's the charge, especially to you as young attorneys, having the privilege. Do you know what a privilege this is? To sit in a law school like this, to gain the tremendous skills that you will gain, that you will take out of here. It is a privilege. This is rarefied air, folks. You have an obligation to take that license that you will get, take that privilege, do something for somebody else. That's King's legacy.
You mentioned moving from feeling like you were another here to your own career arc of being at the top court as a Chief Justice. There's something incredible about that. Can you talk a little bit about how your early work at Southern Minnesota Legal Services has informed your understanding of access to justice?
Absolutely, yeah. My first job out of law school was at Southern Minnesota Regional Legal Services, otherwise known as SMERLS, or Legal Aid, in St. Paul. And I was assigned to the housing unit. So I represented tenants in eviction actions and mortgage foreclosure, but primarily eviction actions. And one of the things you see immediately working for legal services is the access to justice. I wouldn't call it a gap, it's a chasm between the haves and the have-nots. And you see readily how the legal system is structured for those who typically have access by virtue of their. And so the work that I did representing the poor, trying to help them keep a roof over their heads, was so impactful and so meaningful. I didn't get paid financially. I got from my clients, got brownies and cookies and balloons and all of the like, but it was so meaningful to me. When you can help someone keep a roof over their head and the heads of their children, you know you've made a difference. And so that work at Legal Aid, you know, just day in and day out, really made me appreciate how some can be marginalized in our community and how it can seem to some that justice is just for those who can afford to pay for it. And it's seared into my brain and into my heart. That cannot be the case. That cannot be the justice system in Minnesota. And there are so many people that legal aid cannot even afford to help. They turn away thousands of people who do not qualify financially. And so I've taken much of that, Professor Roberts, those initial days at legal aid really seared into me the importance of, in everything that I did in my career after that, advocating for civil legal services, encouraging people to volunteer, do pro bono work for them. When I was in a position to do so, to advocate for funding for civil legal services at the legislature, which I do now as Chief Justice, that is something I will go to bat for day in and day out. Make sure that the attorneys who do that work are better paid. Obviously, they're never going to make what you would make in private practice, but that's not. But also so that the services are there to see to it that all Minnesotans have access to our justice system. So it's something that has carried with me for all of my career.
What roles should lawyers and the broader legal profession play in advancing access to justice?
We have a critical role to play. One of the things I thought was fascinating as I was preparing for this today and looking at King's time, you don't hear much about it, but the lawyers he surrounded himself with played a huge role in the civil rights movement. I would commend to you an article that I read that my law clerk, who's sitting right there, Dahlia, who's an alum of this school, sent to me. It's by Leonard Rubinowitz, and it's out of the Northwestern Journal of Law and Social Policy, the fall of 2016, and it's called A Notorious Litigant and Frequenter of Jails. And it's all about the role that lawyers played in King's life. And he was a notorious litigant and a frequenter of jails because of all the marching and the demonstrating he did. He was frequently arrested and put in jail for that activity. And it was the lawyers mainly lawyers, at least in the early days, from the NAACP Legal Defense Fund, from LDF, who pro bono, were getting their money elsewhere, joined forces with King and represented King in his many jailings, but more importantly, represented many of the other demonstrators and protesters. Because that's what King wanted them to do. He said, it's not just about, it's not just about me, it's about all the other folks that are out protesting. And what I also thought was interesting is most of these lawyers were very young. They were you guys. They were 3 and 4 years out of law school. Fred Gray, who represented Rosa Parks, 24. He had been out of law school maybe like 2 years or something. The passion and the willingness to step into the breach that was so important. He went on to represent King in the entire Montgomery Improvement Association. And so they were there. They played an outsized role. One of the other things I found really interesting, I was looking on LDF's website recently, and they're about to commemorate Bloody Sunday. And one of the things they had on their website was the initial pleading that was filed by LDF lawyers pro bono. It was I don't know if you can call it a pleading, it was styled as such, but it was really an application almost for a permit to conduct the march. And the march actually spanned 5 days, which I did not know. And it is so detailed. They lay out, the strategy and where they're going to march and how they're going to march and what they're going to do and what songs they're going to sing and how they're going to provide for sanitation and litter and when they're going to do this. And I had never seen a pleading like that. And it ends with what they're going to do when they get to Montgomery in terms of meeting with the governor and meeting with various officials. That pleading, that petition, actually found its way into the order that granted the permit for them to conduct them. How huge is that? The lawyers who volunteered their time to draft whatever that thing was, to draft that and have that turn into the order that permits the march on one of the most significant civil rights events in our time. And that's the kind of impact that lawyers can have. It was also the LDF lawyers who helped King, as I said, in many of his jailings, and they were there when he was jailed in Birmingham. And of course, it's while he's jailed there that he writes the famous letter from a Birmingham jail. And one of the things that is talked about in this same law review article is how some of those lawyers actually were the ones who snuck out the letter. They got the letter out and were able to deliver that to the public. And then the last thing I would say is you'll notice when you look at King's career that many of the lawyers also worked on the bigger, broader, impact litigation, big constitutional challenges to segregation. Thurgood Marshall, of course, was one of those as one of the main people, but also Constance Motley. And those obviously were huge. They were significant because they dismantled those cases like Brown and many, many, many others before Brown were able to dismantle segregation in this country. And like I said before, though, it was interesting because I think King saw that impact litigation as important, but that was just a complement to what he thought was most important, which was that on-the-ground activity. Because more Blacks could participate in that, opposed to the big pieces of litigation. But they were both important. And so I say to you, that's the power of lawyers. Want to make a difference? There are so many opportunities to give of your time and your talents. Legal services programs are begging for people to do everything from just get on the phone with a potential client and explain the paperwork they're probably going to need when they go to court. Seems like a little thing to you. To many people, most people, and I would say this regardless of class, the legal system is a mystery. It's something, it's kind of our thing, right? We make up the rules, we enforce the rules, we lawyers and judges, right? That's our thing. But it is foreign to many people. Something as simple as giving basic advice on the phone takes someone a long way, all the way to direct legal representation. Volunteer Lawyers Network, begging for people. You have clinics right here in the law school. You can begin to get involved in that. Or what I'd say to you is find whatever that passion is for you. It doesn't have to be civil rights kind of work. Find that passion. I have a good friend who volunteers tons of time and has done so for years at the Harriet Tubman Shelter for Women. And she helps women secure orders for women, obviously experiencing domestic violence, secure orders for protection. Done it for years. What speaks to you? What are you going to give back to humanity? How are you going to use your license in a way other than to benefit yourselves? Which is important to benefit yourself and your family. That's why you're here. But the practice of law is so much more than that. In our actual rules, we require, or we ask you, we don't require. We do at least 50 hours a year pro bono work. So the opportunities are endless, but find something beyond yourself. I think that's how we honor Jane's legacy the best. What are you doing? The most critical question, he said, is what are you doing for others? You do that, I think you represent the best of this profession, the very best of this profession.
So you've talked about your role with access to justice. You've talked about lawyers' roles with access to justice. What about the courts? How have Minnesota courts advanced access to justice for marginalized communities?
Courts have actually done quite a bit, and I'm proud to say that it. I'll stop doing that. I'll try to stop doing that. I know the people in the sound booth are like, long predates me as chief. The court, I'm proud to say, has a long history of helping self-represented litigants, term that we use now, in terms of we have attorneys on staff who answer thousands and thousands of calls and emails a year of litigants trying to figure out how to navigate the court system. We have kiosks in many of the courthouses, staff in those courthouses at our self-help clinics to help pro se individuals navigate the legal system. One of the things I am most proud of is our legal paraprofessional program. It was a program we piloted about 4 years ago under Chief Justice Gilday to allow paralegals to, under the supervision of attorneys, to represent individuals who are pro se in areas of law where you have a heavy percentage of pro se folks, like landlord-tenant law, like family law. And we piloted that program, and it was a tremendous success. And so these individuals were able to secure the advice of a paralegal at either low cost or no cost. We had to battle initially against some members of the bar, some segments of the bar who were saying, well, you're taking business away from attorneys. Law school, we owe a fortune, in loans. You're taking our business. And my answer to that when I became chief was, you weren't doing that work anyway. You were not doing it. Let's be honest. You were not in court at housing court in Hennepin County. We're not taking business from anyone. What you're doing, and this goes back to my experience at Smurls, is providing that access for other people. Because we all know in this room, when lawyers are present, the outcomes are usually different for people in terms of what you're able to negotiate, what you're able to do for a client. And I'm proud to say that the court made that program permanent this past year and expanded the categories where paralegals can debt collection and expungement and a number of other areas. We just started a jury task force. And that's something that's near and dear to my heart. When you look at our juries here in Minnesota, while our process for jury selection has passed constitutional muster by our court, that's the floor. Because when you look at our juries here in Minnesota, they are oftentimes not representative of the defendants, criminal defendants in particular, who are in those courtrooms. You have a constitutional right to a jury of your peers. That is not what our juries look like right now. And so what I wanted to do is to put a task force together, and what Judicial Council has authorized is to do that, is to look at what are the barriers. How are we selecting? One of the things we know makes a difference, I was talking to a colleague in California where they have increased the juror per diem to $100. I think several states, including North Dakota, has done that as well. And we know the data show that the per diems make a difference in terms of diversifying our jurors. In Minnesota, we pay jurors a whopping $20 a day. You cannot park at the Hennepin County Government Center for $20 a day. And what it does, though, is for low-income folks and moderate-income folks, or folks whose jobs depend upon, like hairstylists, who are often independent contractors, they make their money by who is sitting in their chair every day. How many clients are sitting in their chair? They cannot afford, and many other people cannot afford, to participate in jury service for a week for $20 a day. So you're excising out a huge swath of Minnesotans. There are a lot of people in that boat. So one of the things we are trying to get through, we had talks about it at the last legislative session, but we're pushing it again. When I say we, the judicial branch, is trying to get through the legislature an increase in the juror per diem. The other huge thing that I think has been just fundamental for the branch is remote hearings. There are pros and cons to that. What's interesting is, but I think by far, it is a benefit, and it has really opened access, increased access to our courts. What's interesting is we started doing remote hearings out of necessity during the pandemic. The pandemic is what drove that, because suddenly the courts were shut down. Everything was shut down. You could not go to court physically. You could not have jurors sitting, side by side. And remember, in the early days, this was before the vaccines, before masks. This is before we knew how COVID-19 was transmitted. We were still wiping the desks, remember, not recognizing that it was transmitted through breath. So the courtrooms were closed, and so we pivoted to remote hearings. And I don't have to tell anyone in this room, the law doesn't do anything quickly. We are like a ship, we're like that. That's how the law, but we were forced, the branch was forced, in order to protect people's rights. You still had a right to have your cases heard and to have justice delivered, to pivot on a dime to remote hearings. We did that for 2 years. Coming out of that, as I became chief, we did that under Chief Justice Gilday, to her credit. When I became chief, the issue was, do we continue it? Over the last year, I have decided, along with Judicial Council, yes, we're going to continue that. Clearly, there are hearings and proceedings that cannot and should not be done remotely. There will never be a felony criminal trial held over Zoom. That's not going to happen. But what we've done is we've gone through all of the various case types and assigned them a presumptive category. What hearings and proceedings are presumptively remote, and exceptions can be made, but what are presumptively in person? What it's done, I will, I will tell you is, and I'll go back to housing law once again. I stay in touch with my legal aid folks. If you are in greater Minnesota in particular, and you have an eviction matter pending, sometimes the travel distance in to our courtrooms, our courthouses is huge. People drive 30, 40, 50 miles sometimes to get to a courthouse or to even see their lawyer. That's an access issue. What remote hearings have done in the housing context and in many other contexts is allowed people to not have to make that drive. They don't have to find daycare. They don't have to figure out how to get there because they may not have the transportation. They can get on the Zoom, talk to their lawyer, appear at the hearing. It allows legal aid attorneys to represent far more clients than they otherwise would be able to because they can go via Zoom from courtroom to courtroom. That has been a game changer in greater Minnesota. Here in the cities, it allows, to just flip the whole thing, it allows an attorney at Taft who's got a 15-minute scheduling hearing for a corporate client, sit in his or her office, because those are presumptively remote, and do that same hearing, not charge the client, not drive to the courthouse, and do that same hearing remotely. So I think the remote hearing process has been a tremendous game changer and benefit on an access level and leveling that playing field for people. There's some downsides to it, and I hear about them often because there are certain hearings which we've designated as remote that people don't think should be remote. We're gonna, it's still a work in progress. A judge friend of mine who does primarily civil commitment has told me, Chief, and we've said those are presumptively remote. She tells me on a regular basis that we should not be committing people potentially for the rest of their lives to St. Peter over Zoom. I want to see them. I want to see them. I want to talk to them. Here's similar things in our juvenile area. A lot of our juvenile proceedings are presumptively remote, and many juvenile court judges will say to you, I need to see these kids. I need to talk to them. Because a lot of what judges do is legal, but they're also almost playing the role of parents and psychologists and social workers, and you're trying to keep kids on the straight and narrow. Hard to do via Zoom. So we're looking at those things, but overall, that has been an access issue for the courts and access to those who might not otherwise be able to afford it and to have it. And I'm very proud of that.
We have about 5 more minutes, so I want to get to this, some student questions that they submitted. And for this question, I'm going to combine 2 student questions into one. It goes, how are justices on the Supreme Court able to engage with each other so respectfully in the current divided political climate when you disagree on so many important issues? And the second part is, and how can that be a model for us in society?
Good question, and we do sometimes disagree on the court. You know, the cases that come to the Minnesota Supreme Court are often significant constitutional issues, as you have seen lately. You follow the news. But cases of great import, and sometimes feelings are strong, and tempers can flare every now and then. But one of the things that we do as a court, we recognize that what is most important is the court as an institution, and protecting the court as an institution and its reputation as an institution for making decisions based upon the rule of law and not our individual feelings about things. So sometimes we get by those difficult discussions because we all recognize and value that it isn't so much about us individually, what we may think, as it is about the court and how the court is perceived. The other thing is we foster collegiality within the court. I see one of my principal roles as chief is to make sure that we're doing that. And so we do that through very symbolic things, but also very substantive things. The symbolic, but nevertheless important, are things like when we're in conference talking about a case, maybe we're split, maybe there's a dissent, a strong dissent. We're talking about a case, we always refer to each other as Justice. So when I'm talking to Justice Hennessy, it's Justice Hennessy, Justice Teese. We never call each other by our first names, even though we know each other very well. I mean, we spend a lot of time together. Sam Hansen used to be on our court, and a great lawyer, said one time, and Court of Appeals judge too, the neat thing about the Supreme Court is you've got these 7 talented people, working together. And he said, and the downside about the Supreme Court is you've got these 7 talented people working together. They're always there, You come back the next day and they're still there, And so, but we do that out of respect for them. So that even though I may disagree with you with the opinion that you're articulating to me, you are still Justice Hennessy to me. We talk a lot about our opinions and how we write them and what we say, particularly if there's going to be a dissent. You can disagree without being disagreeable. We talk about the importance of them not being personal. And if one of us sees something that seems to be cutting a little personal in that dissent, we all know that we're free to go down the hall to one another and say, can you walk that back a little bit, soften that. So it's a commitment to the broader endeavor, I think, that keeps us civil. And there have been occasions when we have had to say, the chief has had to say, both before me and me, let's take a break. Sometimes when things really get going, this is true in your own lives, in all of our personal lives, there's some things you can't take back. And so before you say something you can't take back and you can't make right, sometimes you need to take a break from that. And so we find the things that we do agree on. We talk about how it is we talk to one another. And as I said earlier, there's a way to say everything. I don't have to say to you if I disagree with you, that's the most idiotic thing I've ever heard. That does not foster collegial discussion. What might foster it is say more. Why do you say that? Or that opinion doesn't seem to take into account A, B, C, and D. Opinion change if you said that. Or how can I maybe accommodate what you want to say? And we have those discussions often in we don't give up our principles, but we are willing to say, I think I can accommodate that if we say it this way, or we do it this way, or we decided on this ground as opposed to that ground. So you have to be intentional, and you have to be intentional about what are the broader things you can agree on. So many things we can all agree on. So many things we all want. We all want our families to be healthy. We all want our children to do well and to go to good schools. And we all want those things. What are the things that we have in common? And then on the things that we don't have in common, talking about how you get there. Professor Roberts was showing me a picture that he took of part of some class where it's just an average-looking family in their living room or in their dining room eating dinner, but laying against the fireplace is a gun. And the symbolism of that is that's just normal and what they do. Gun ownership is, who they are. If that's not your orientation, that gun sitting there means something totally different. But we can talk across those those divides if we're willing to acknowledge that not everybody's experience is the same and be willing to try to talk through those.
Justice Hudson, thank you so much for an engaging and enriching conversation. Please join me in thanking Justice Hudson.